Hello students, I am Dr. Harpreet from Army Institute of Law. The topic for the day is Concept of Positive Secularism in Indian Constitution. Introducing the topic, the idea of secularism plays a big and vital role in the fields like political science and constitutional law. Secularism has always been practiced in India because the phrase was not introduced to or included in the initial draft of the Indian Constitution written by the Constituent Assembly. The Hindu religion's diversity in terms of religion is highlighted through texts like Vedas and Upanishads. Similarly to this, Indian rulers Ashoka the Great declared that the state will not participate in any religious activity in the 3rd century. The two groups, Sufi and Bhakti, gave Muslims and Hindus a new way to express their religion during the Middle Ages and united other communities through love and peace. They left an imprint on the Akbari era through the idea of religious tolerance. It was discovered that the freedom movement strengthened the idea of secularism during the British era in all the nations. The term secular was inserted to the Indian Constitution by the Parliament during the 42nd Constitutional Amendment. The Constitution of today reflects secularism in its core. India has adopted the principle of a secular state with the 42nd Constitutional Amendment. This idea holds that the state is neither pro-religion nor anti-religion. The government does not practice any religion and does not support any particular community's religious activities. The state's primary tenets are Sarv Dharma Sambhava, which translates to all religions are the same, and Dharm Nirpakshta, which refers to the state's lack of regard for religion. It should be mentioned that the term secularism has different meaning in different countries. For example, in the United States of America, the term refers to the separation of the government from the religion. In UK, secularism is seen as a form of religious tolerance. In contrast, secularism is seen as anti-religious in the Soviet Union. It might be claimed that the Indian definition of secularism differs from the Western concept in this sense. However, the idea of communalism, which primarily focused on foregoing a religious identity, has given the secularism in India a new viewpoint. The idea of secularism, as it is understood now, is somewhat comparable to that of Pandit Jawaharlal Nehru. According to him, secularism, as it relates to the state, signifies that the state has no particular religion and that all religions are to be protected. On the other side, Mahatma Gandhi saw secularism from non-communal perspective. He believes that secularism entails respect for all religions. His view of secularism is comparable to that of United Kingdom and is founded on Hinduism. Now I'll be discussing with you the origin of the word secularism. According to the modern literature, secularism has its origin in Western countries and it is related to the separation of the church from the state which gives state a position of neutrality between different religions, while at the same time it guarantees all citizens right to adhere to any religion. According to Gharana 1998, Kar 1998, Sharma 2000, Talesra 2002, and Yarnkar 2006, G.H. Holyoake has been regarded as the originator of the concept of secularism because of his important work such as Principles of Secularism and The Origin and Nature of Secularism. A secular state, as defined scientifically, means a state which recognizes every citizen as equal and does not recognize any social or religious stratification for any political benefit. But what is generally projected as secularism is tolerance of all religion with special emphasis on the protection of minorities and preservation of communal harmony. However, in the words of Rizvi in year 2005, the essence of secularism rests on the two basic principles. First is separation of religion from politics, and second is acceptance of religion as purely and strictly private affairs of individuals having nothing to do with the state. Sometimes the word secular is used as a contrast with the word religious, which lead people to believe that secularism is opposed to religion. But in reality, rather than remaining opposed to religion, secularism take a dispassionate view in running the affairs of the state. In the context of India, it is basically connotes treatment of all religions on a footing of equality and ruling out any discrimination. Hence, secularism means separation of the state, politics, and non religious areas of life from religions, and religions being treated as purely personal matter. So, when India is said to be a secular state, it only means that the state will not identify itself with any particular religious faith and that no person shall suffer any disability or discrimination on the basis of religion. Now, coming to the meaning of term secularism. Secularism means that the state does not give shelter to any particular religion. Secularism is not an atheism but has the same faith in all religions, and there will be no particular religion of the state. Also, political system will not be governed by religion. Citizens of different faith may be living in these states. Every citizen can live life freely according to his or her religion. This is the meaning of secularism. In Indian tradition, secularism can be defined in the following three ideologies. One, liberal ideology has endorsed the Western concept of secularism. Politics and religion should be completely different. Religion should not affect politics, and politics should not be affected by religion. Both things are agreed differently. Second, the transformationalist ideology emphasizes social, economic, and political development. This ideology recognizes that religion should be limited to the private life of the individual and should try to create scientific perspective among the individual. Third, the Gandhian ideology has taken a different role than liberal and transformational ideology. The Gandhian emphasis religious tolerance and religious bigotry. Religion and politics are interrelated and cannot be separated. Gandhian believe that religious values are essential to the political morality. With the influence of the above three ideologies, the nature of Indian secularism is different from that of Western secularism. Although religion is considered separate from the politics in India. In individual life, religion is accepted. The positive concept of secularism developed in India that the state should adhere to this principle without any political use of religion. Thus, despite the greatness of India, the integrity of the nation has been maintained. The global spread of the word secular. Around a century ago, the Latin word seculum, which refers to a set period of time, served as the inspiration for the English word secular. In the Romance languages, this evolved into century. In Christian Latin, the idea of secularism was helpful for defining the boundaries between God's divinely everlasting realm and our earthly age. Something secular has to deal with all kinds of affairs as opposed to theological matters. The Oxford English Dictionary gives the definition of secular as follows. It states belonging to the world and its affairs as distinguished from the church and religion, civil, lay, temporal. After explanation and discussion by the philosophers who saw more and more plausible and imaginable affairs that should be distinct and autonomous from classification and regulation of religion, the word secular gradually acquired additional meaning. Two major instances are the gradual breakdown of the capitalist economy and democratic politics in the 17th and 18th century. The secular came to be regarded as having phases, a beginning, and the potential to occasionally evolve gradually. As a system, it is regarded during the 19th century more secularistic, academic, and activists envisioned an ideal society that would be entirely secular. Although the idea of secularism has been present in our culture and traditions since the beginning of civilization, George Jacob Holyoake coined the phrase in year 1846. He defined the term as it actually exists, a belief system that solely cares about hypothetical questions that can be tested by this life's experiences. Secularism does not directly refer to the idea of being anti religious in relation to religion, rather, it refers to idea of focusing on this life rather than making assumptions about other natural lives. This undoubtedly eliminates some religious belief system, most notably Holyoake's Christian religion, but it does not necessarily exclude all possible religions. Nowadays, the term secular denotes an expression exemption from religious norms and lessons. Coming to the philosophy of Indian secularism, the term secularism is akin to the Vedic concept of dharma nirpakshta, that is, the indifference of state to religion. This model of secularism is adopted by Western societies, where the government is totally separate from religion, that is, separation of church and the state. Indian philosophy of secularism is related to Sarv Dharm Sambhava. Literally, it means that destination of the path followed by all religions is the same, though the path themselves may be different, which means equal respect to all religions. This concept, embraced and promoted by personalities like Vivekananda and Mahatma Gandhi, is called positive secularism that reflects the dominant ethos of Indian culture. India does not have an official state religion. However, different personal laws on matters such as marriage, divorce, inheritance, alimony varies with an individual's religion. Indian secularism is not an end in itself, but a mean to address religious plurality and sought to achieve peaceful coexistence of different religions. Now, I'll be discussing with you the key features of positive secularism in Indian context. The position of secularism in India can be seen as follows: equal respect for all religion. The Indian state recognizes and respects all religions, ensuring that no religion is given preferential treatment over others. Freedom of religion. Article 25 of the Indian Constitution guarantees the freedom of conscience and the right to freely profess, practice, and propagate any religion subject to public order, morality, and health. Further, we have cultural and educational rights. Article 29 and 30 protects the right of minorities to conserve their culture, language, and script, and to establish and administer educational institutions of their choice. Non-interference and non-promotion. The state does not interfere in religious affairs unless necessary to ensure social reform or to maintain public order. For example, practices like untouchability and discrimination are abolished under Article 17. Secularism in governance. The Indian state is expected to govern without bias towards any religion. This includes maintaining a secular character in public institutions and the laws. Equal treatment under the laws. We have Article 14, which ensures equality before the law and equal protection of laws which extend to all citizens irrespective of their religion. Prohibition of religious taxes. Article 27 prohibits the state from compelling any citizen to pay any taxes for the promotion or maintenance of any particular religion or a religious denomination. Secularism and the Indian Constitution. India is a secular nation and it guarantees religious freedom and right to propagation expressly, and there seems no interference by the state in the religious matters unless or until it's not violating basic human rights or having impact on health and public order. At the outset of the making of the Constitution, the concept of secularism was not expressly mentioned in the Indian Constitution. However, the Indian Constitution has spelled out several provisions in Part 3, that is the fundamental rights, in Part 4, that is the directive principles of the state policy, and in Part 4A, that is the fundamental duties, and it reflects the existence of secularism. Following are the constitutional provisions which are pertaining to the secularism. First is the concept of equality and non-discrimination. We have Article 14 of the Constitution which provides that the state shall not deny any person equality before law and ensures equal protection of law within the territory of India. Then we have Article 15 which have been expressly mentioned, which was impliedly held in Article 14, that states shall not discriminate against any citizen on the grounds of religion, race, caste, sex and place of birth. Article 16 goes further and promote equality of opportunity for all citizens in the matter of employment and opportunities, and no citizens on the basis of religion shall be discriminated. Although in the above article, reasonable protections are provided and benefits of reservation is provided, but it's not a basis of religion. It is not a favor of arbitrary, rather, it's intelligible in order to protect and uplift the lower section of society and fulfill the principles of socialism, and inadvertently it promotes secularism. Traditional and deep-rooted concept of untouchability was abolished by Article 17 of the Constitution. Further, we have Article 23 Clause 2 which provides that when state imposes any compulsory service on citizens for public purpose, there shall be no discrimination on the basis of religion. Now we have the concept of freedom of religion, which is given under Article 25 of the Constitution. Article 25 provides that all persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate religion. But this right is restricted in the sense that it should be subjected to public order, morality, health, and other provisions of the Constitution. State can pass laws providing for social welfare and reform, also to regulate or restrict any secular activities, that is economic, financial, or political, etc., even if it may be traditionally linked with the religion. Every religious denomination or any section thereof has the right to manage its religious affairs, establish and maintain institutions for religious and charitable purposes, and own, acquire, and administer property of all kind as provided under Article 26 of the Constitution. Article 27 discusses about the freedom as to the payment of taxes for the promotion of any particular religion, by virtue of which no person shall be compelled to pay any taxes. No religious instruction shall be provided in the school wholly maintained by the state funding as provided under Article 28. Religious and linguistic minorities are free to establish and administer educational institutions of their choice, which shall not be discriminated by state on matters of granting aid or compensation as given under Article 30. Article 29 provides that every section of the citizens having a distinct language, script, or culture of its own have the right to conserve the same. Further, we have Article 51A subclause E, which provides that it is the fundamental duty of all the citizens to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, regional, and sectional diversity, community specific constitutional provisions. Further, we have Article 48, which provides that state have to take steps to prohibit slaughter of mulch animals, although scientific interpretation can be made out of the provision. But give a communal color, it's for the protection of Hindu faith as they considered cow as a deity. Further, we have the explanation 1 to the Article 25, which allows wearing and carrying of kirpan as essential practice of a Sikh religion. This doesn't mean that state is favoring any religion. Rather, it's providing protection to the religion group to maintain its identity and enabling a person to profess his religion. Coming to the Article 290A, which provides for the grant of specified annual maintenance or allowances to be given from state exchequer for the upkeep of Hindu temple of a certain denomination in two South Indian states, that is Kerala and Tamil Nadu. Then special provisions of transitory nature is provided for Anglo-Indian community, which is given under Article 331, 333, 336 and 337 of the Constitution. Now, after discussing the constitutional provisions, I am coming to the interpretation through the court regarding the concept of secularism. The Supreme Court expressed its view first time in the case of Sardar Tehruddin Saidna Sahib versus State of Bombay. This case was in year 1962 and it is given under page number 853, where the court had opined that religious toleration is fundamental principle of the constitution, which has been embodied in Article 25 and 26. In the case of Keshwanand Bharti case of year 1973, the Supreme Court expressed the views that secularism is a part of basic structure of the constitution. However, It was in Ahmedabad in case of St. Xavier College Society versus State of Gujarat in year 1974 that Supreme Court tried to investigate into the Indian model of secularism, where Supreme Court expressed that Indian secularism does not draw a clear wall between the church and the state. In Indian context, secularism only means live and let live. In a leading case of Ziauddin Burhanuddin Bukhari versus Brij Mohan Ramdas Mehra case, which is of year 1976, the Supreme Court illuminates the role of state in secularism. The role of state in secularism must be neutral and impartial, and it must extend benefits to all the caste creed. It is the duty of the states through their laws to ensure that the conditions are not imposed merely on the basis of someone's caste or religion. Next, in the Indra Sani case of year 1992, the Supreme Court extends its ambit of secularism, inequality before religion, to equality before the caste. Justice Kuldeep Singh ruled that secularism proposed a united and casteless society. He had gone further, stating that secularism envisages a united and casteless society. In a landmark case of S.R. Bommai versus Union of India, this is 1994 case, quoted at page number 1 of SEC, court expressly declared that secularism is a part of basic structure of the constitution. However, there seems some ambiguity in the definition of secularism. Ahmadi justice stated that secularism is based on the principle of accommodation and tolerance, whereas Jeevan Reddy and Agarwal in their judgment went further, stating that Indian secularism is in agreement with the First Amendment of US Constitution, which shows that there is a certain ambiguity in the exact definition of secularism. However, in Dr. M. Ismail Farooqi case, which is of year 1994, quoted at page number 3 to 4, there seems some shift from the older view previously expressed in S.R. Bommai case. Verma Justice, the Supreme Court expressed the view that Indian secularism is based on the principle of Sarv Dharm Sambhava. The court seems to have again rejected the concept of a clear separation of church and state that was confirmed by the S.R. Bommai case and went back with the doctrine of secularism with tolerance. This view in Ayodhya case seems in agreement with its older view in excommunication case and Nain Sukhdas versus State of UP. However, the dissenting opinion of Bharucha justice seems more consistent with S.R. Bommai case, where he advocated absolute positive and active secularism. The Ramchandra K. Kapse versus Haribans R. Singh, which is a leading case of year 1996 and it is given at page 206, was again a change from the previous judicial decision of the court, where the court has gone further equating Hindutva and Hinduism, which depicts the way of life of the Indian people. Hindutva judgment may be criticized for the fact that court failed to consider the long essays written by V.D. Savarkar, where he proposes Hindutva as political ideology. This must be understood clearly that constitution or law of the land cannot be interpreted in the lights of any political ideology, or it must not be influenced by any political ideology. However, N.P. Singh and Venkatswamy justice in case of Muhammad Aslam versus Union of India, 1996 Supreme Court cases, page number 749, clarified that there is no contradiction between Hindutva judgment and Sarbamai. There is no consensus in various decisions. Therefore, a unanimous interpretation of secularism is critically needed. In Abhiram Singh versus C.D. Cormacan 1996, which is on page number 665, quoted to recommended the question to a larger bench for consideration. In Valsama Paul versus Cochin University of 1996, the restored to its earlier view of equating secularism with tolerance while stressing on the need of integrated India or integrated Bharat. Again, in a case which is a very important case, which is known as Bansilal case, it is an agreement with the SR Bomai case where the court ruled that state could regulate personal laws citing threat to the unity and integrity of the nation. Whereas in A.S. Narayan Dikshitulu versus State of Andhra Pradesh case, which is of 1996, the court commented that the word dharma in Hinduism denotes upholding, supporting, nourishing, that which upholds, nourishes, or supports the stability of the society, maintaining social order and general well being and progress of the mankind. In conclusion, there is ambiguity in interpretation of concept, but the court seems to have been restored to its earlier view, which was equating secularism with tolerance. It can be deducted from most of the cases that court has rejected the view of clear separation of concept of church and state, and the concept of secularism in India is mostly based on the concept of Sarv Dharam Sambhava. The concept of active and absolute secularism, even though accepted in some cases, has been rejected in most of the cases. Now, coming to the concept of the relevance of secularism in India. Religious plurality in India makes secularism very important to be present in India. India needs to resort to pluralism to keep itself integrated. Secularism, as an ideology, tries to keep the nation united on non-religious front like financial development, better education, etc. These move the focus of individual from religion to other important things that could change the present for a better and brighter future. Presently, the development of Hindutva as a significant counter-ideology has functioned as a trigger for intensification of the secularism discussion in India. Hindutva ideology, often known as religious nationalism or Hindu nationalism, is a nationalist ideology that is critical of the kind of secular philosophy that governs the Indian constitution. The debate over the adoption of a uniform civil code is exemplified by the contradiction between two constitutional rights. On one hand, the right to equality and non discrimination is granted under Article 14 and Article 15, and on the other hand, religious freedom and cultural plurality are granted under Article 25 and Article 28 of the Constitution. Enacting a uniform civil code, which is given under Article 44, is only a directive principle of the state policy and is not binding on the state. However, equality and multiculturalism are the rights given to the citizens and are justiciable. It is within Article 44 of the Constitution that one needs to study the statements by the Supreme Court that suggest the enactment of a uniform civil code. Concluding my topic, I can say India is known as a secular nation across the world. Secularism per se means a mode of governance in which state remains neutral in religious matters and is not supposed to tilt in favor of a particular religion. However, to protect the interest of minorities, specific provisions have been made in the Constitution which indirectly reflects that specific discriminatory provisions have been made in the Constitution. In a secular state, majority and minority should be treated equally. Apart from the above, whenever the word minority was to be considered by the government, the attention had been paid only to religious minority, whereas the provision in the constitution is religious and linguistic minority. So, if the interest of minorities is going to be protected by the government, then the constitutional meaning of minority should be taken into consideration. Otherwise, the spirit of the constitution will be defeated. In 2019, the central government brought the Citizenship Amendment Act of 2019 to protect the interests of six religions facing religious persecutions in three neighboring countries, but was strongly opposed by various groups, saying that non inclusion of Muslims in its purview is discriminatory and also against the concept of secularism, which is the basic structure of the Constitution of India. And also, the basic structure of India cannot be changed. But one thing must be kept in mind that the basic structure theory was developed by the Supreme Court of India as a limitation in the power of the Parliament to amend the Constitution. Normally, a law that came through enactment cannot be challenged as violating the basic structure. CA of year 2019 is not part of the constitution, so it should not be challenged as violating the basic structure of the constitution. The Supreme Court of India is the guardian of the constitution, and whenever any dangers come to affect the secular character of the country, it is always ready to protect the secular character of the nation. That's all for today's. See you in the next talk. Till then, thank you. Goodbye.